Hello, hello. Sorry, I was a minute late there. Yeah, I got a couple fun clips. I have to thank Rocky Lennon and Marion sent me another one. It's pretty good stuff for a Sunday with no court. I did do some court stalking around, basically in Detroit, and there was one other call, but I couldn't find anything exciting happening today. I really couldn't. That's all right. We've got stuff. The big question. The age-old question we're going to ask, is Mom drunk? Let's do this.
Hello.
All right, good morning, afternoon, ma'am. Miss Wendy.
What the judge says.
What is your name? You're Wendy Jesnick.
It's Dumas, Dumas.
Is your name Wendy?
Yes, my name is Wendy. My last name is Dumas. It's not James.
Is your middle name Irene Francis?
Yes, ma'am.
You've been charged with one count of arson. That bond is $5,000.
Arson.
Criminal trespass, $2,000, and giving false name, address, or date of birth, $1,500.
Man, Mr. Dumbass. The name is Dumas.
You have a stay away condition to stay away from the Georgia Truck Parts Company, Inc. on 46170 Old Dixie Road in Forest Park. Your preliminary hearing for the given false name is going to be on September the 11th. For the remaining two charges of arson and criminal damage, that preliminary hearing is going to be on September the 11th. And I did appoint counsel to represent you, ma'am. If you have no questions, you're free to go.
I have questions. I have a lot of questions, actually. Can I speak with you? Are you?
No, step down.
Can I speak with you in your?
Step down.
No, I'm worried about my life here.
Come on.
I've charged
Judge, I'm ready.
you.
Yeah, please do. Somebody put him back in that cell over there.
Bowden, it's cause number 138536, and I believe that Ms. Bowden is present on Zoom.
I don't know. Oh, is that B? Alexander B. All right. And Ms. Bowden, hello.
Hi.
And we're here on, so there's an allegation of
Girl's
an
got
auto
some
loan, I
claws.
think it was.
Watch out.
$3,500 some dollars. United Finance is collecting against that. Their attorney's Mr. Yannick. And Mr. Yannick on their behalf is asking for something called summary judgment, which would say that there isn't any reason for this to go to trial and that the court should sign off on this and settle that debt that you owe. So let me hear from Mr. Yannick.
Thank you, Honor. So this matter was continued from July 19 so that the defendant could consult with an attorney and respond. I'll just very briefly restate the facts of the case and tell you where we are today. So this is a vehicle loan deficiency with the plaintiff as the lender. The answer generally disagrees with the amount. Defendant alleges that the vehicle was not sold properly. However, there was not a repossession. So there's no repossession. There's no resale credit, none of that. Plaintiff did respond to the summary judgment, but that response was essentially an unreadable form declaration of income and assets, but there was nothing that addressed the merits of the case. So plaintiff's position today, as it was on the 19th of July, is that there are no genuine issues of material fact, and therefore plaintiff is entitled to judgment as a matter of law today, Your Honor.
And just looking. So, Ms. Bowden, then this is not the data so much so that we have trial, but the response to that we gave you an opportunity to respond to, were you going to be doing more or what? Where are we today from your point of view?
I'm getting mixed reviews. I ended up talking to more than one lawyer, and one of them.
She's getting mixed reviews. I find that hard to believe.
Kind of just advised to explain
I'm
my.
not here to, I don't want you to get in the middle of your legal discussions with other lawyers, and what they say today really doesn't mean a whole lot, but what was your plan going forward?
I feel like I have sufficient cause or reason that there was no payment made, and that was based on an arrangement made with the manager at that
Uh-huh.
time of United
Okay.
Finance Company. He made an
What kind of arrangement are we talking about here? Did a burrito change hands? That's what I need to know.
agreement with me based on some faulty and I think illegal sales issues during the purchase of the car, which I did actually take to the Attorney General. They did try to
I
mediate.
don't
All right. Stop feeling and stop thinking. It's not working for you.
have anything from you, though. I don't have any
I-
response.
So,
I
like, as
get,
far as our agreement, I wouldn't know like what I could provide to, because it was an over the phone verbal agreement. So assuming that, you know,
I mean, I'm just making this up, Judge, and I don't have any proof of it. So you're gonna have to take my word for it.
it's a bank, maybe our call was recorded, but aside from that, I don't know unless I could summon him, the manager at that time, and to testify that he said that, because you know, the payment ledger says that there was no payments made, but then it shows a payment made, and I'm not sure like why that amount was deducted. It just none of it really adds up. But I was told by the manager to
Okay, so if you are confused about it, then you're okay. That's just the general consensus of these people. Like if I don't understand it, then everyone else must be wrong.
not make any payments because of what the sales people did in selling me the car. They did not tell
Well-
me it had a title. They knew it had one. And then they threatened me days later to come back and re-sign the contract.
so we're
which
in the
rem-
same place we were in July when the court gave you a continuance.
Right, and I did consult with the Northwest Justice lawyer. I did submit some of the documentation. I have a couple voicemails. I have some other things that show, you know, that the
challenging
contract
it
was manipulated.
Okay, in what way?
in a good way.
So to what extent of any other information I could get to support that. I'm trying to figure that part out. There's something out there. There has to be. So I'm not
Right,
sure.
this case was filed May of 2020.
Judge, I know my evidence is out there somewhere. If we continue this another 20 years, and as soon as it floats in, I'll let you know.
And we're here in July of 2024. So,
Yeah, I'm
and
not
yet
sure.
that was, 20 days, or served on you at some point. Let's see. Yeah, see back when you were served. So,
I was served a long time ago. The rest of it I received by mail. That was why we had done the continuance, because I received
Right.
it shortly before. So it was kind of a scatter to even get to speak with a lawyer, but I did the
yeah.
best I could for that amount of time, you know. So
Well, Ms. Bowden, there's no basis. I mean, the merit is on the side of United Finance here from everything in the court's purvey here that summary judgment should issue on behalf of United Finance. And so I'm going to sign off on this summary judgment. There isn't any issue that's been shown that genuine issue, material fact that should go to trial. And
Yeah, so you're awarded 0 points, and may God have mercy on your soul.
the company is due this judgment by matter of law. So I don't know if that assists you with United Finance and coming good on this and contacting them and seeing if there's some sort of arrangement, but at least now they know they don't have to be in court anymore on this one and pay more lawyers. So that may be helpful to them and may be more interest to them to talk to you about how to settle that debt. But
okay. So
yeah, that's all for today then.
Okay,
The
thank
form
you.
that I
Hunter.
filed for the income and assets, I believe does show that I'm judgment proof because of my income.
That's a whole different animal. I've just simply signed off on the summary judgment.
Different animal, and for what it's worth, it
So that's nothing to be proud of, Russ, and it's not a defense.
was completely illegible.
Oh, that must have been the facts that, I mean, I filed a perfectly legible version with the court, so it must have just been facts.
All right. So,
All right.
Mr. Yannick,
I mean, look at the attention she gives her lashes and her nails. You know that was clear as a bell.
any other cases?
No, nothing further from me, Your Honor. Have a great day and weekend.
All right, and Ms. Bowden, you can be on your way as well.
All right.
Thanks.
On August 9th, officers were dispatched to a terrorist threat call at a home. Complainant stated he was cleaning the outside of his home. When the defendant grabbed the garbage can and threw it at the complainant's vehicle, the complainant got in his car to go to the store, and then the defendant got in the way of his car so he couldn't leave the driveway. Complainant then went into his garage. The defendant started making cat noises and called the complainant a pussy and stated, "I am going to whoop your ass."
All right. This is a citation issued on July 3rd of this year on 116th Avenue there in
That was Marion's fault, but I really enjoyed it. The defendant couldn't even hold back a smile. He's like, "Yeah, okay, I made cat noises and called him a pussy. I did it.
Watson Township. This is for a speeding citation on an actual 68 and a 55. However, it was only written as a 1 to 5 over. Mr. Ghazal, you're here on this citation to do one of three things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened, or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I'm looking to contest this ticket, Your Honor.
All right. Then the first thing I'm going to do is swear you both in. If you could raise your right hands.
Challenging it
Okay, in what way?
in a good way.
Yes, sir.
All right, Mr. Ghazal, it makes a lot more sense to me. Start with that deputy. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have the opportunity to either ask questions or testify in your own behalf. And with that, deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
On that date and time in question, was using my moving radars, a Raptor RP1 radar unit. They tested both at the beginning and end of my shift to ensure it's functioning. Observed the defendant's vehicle traveling westbound, appeared to be going over the speed limit. When I activated my radar, showed that he was going 68 miles per hour in the 55. The tone of the radar was consistent with what I was seeing. Upon stopping him, I decided to write him for a 1 to 5 over instead of the full 13 over.
You said moving radar, so you were traveling.
I was traveling eastbound. He was
Opposite
traveling
direction.
westbound.
Okay. All right, and Mr. Ghazal, what is it you'd like to say?
So, I'm certain that Officer Schmidt's moving radar detection device had misread my speed for another driver's. Moments before I was pulled over, I was headed west of 131. I witnessed this driver heading in the opposite direction as I was, making an attempt to pass the vehicles in front of them. Now, obviously, in order to pull this off, one would have to speed to effectively pass the vehicles around them, though once this person saw me, they immediately steered back into their lane to prevent themselves causing a head-on collision with me, because they were that close to cutting it. Now, right after that very moment is when I first saw Officer Schmidt. He was a couple to a few cars behind the driver in question. And to my surprise, he immediately turned around to pull me over. As I'm sure this is an honest mistake, I'm certain that the radar provided an inaccurate reading with a lack of resolution that had mistaken my speed for the driver that was trying to pass others.
All right, Mr. Ghazal, those are two different radars, though. Same direction radar and opposite direction radar are two different devices. So
Wah, wah, wah. This judge has also been to Radar Fantasy Camp. It's not going to fly. He made a really nice argument aside from the fact that it's wrong. He gave a good presentation of an argument, but he didn't realize that that's just not how it works.
If you're explaining the movements of a car traveling the same direction as the officer, that would have had to been him using his same directional radar, not his opposing traffic radar. But I'll have the deputy articulate that. Deputy, is there any chance that the car that you picked up was a car traveling in your own direction who was moving at a high rate of speed?
No, I was using my opposite direction radar. That's the default setting. That's what I was set to. And that's what I was looking for, was people traveling opposite direction of me.
Yeah, so Mr. Gazal, I understand your argument, but sir, it just simply wouldn't affect a vehicle that was traveling in the same direction as the cruiser. So that being the evidence, I would find here that you were traveling at least 1 to 5 miles over the speed limit. You would have those same appellate rights on this matter as we just went over. Do you feel like you understand those?
Yes, sir.
All right, then we are all set here. I'm going to go ahead and release parties.
I am. How are you, referee?
Okay, good morning, Mr. Nowicki.
Hello, sir.
Good morning, Ms. Van Dyken.
Good morning, Your Honor.
Good morning. All right, let's go ahead and go on the record in the matter of Nowicki versus Evans, case number 23-03464 DC. Mr.
So I found it a little odd that he didn't mean to, but he says good morning to everyone except Mom here. After you hear talk, you'll see why. This one is really sad. I already know. Pro clutchers just go away as usual. But it's also interesting and kind of funny.
Kazari, this is your motion.
Thank you, Your Honor. Your Honor, we're asking the court to enter a temporary order for parenting time. Essentially, what's happening now is that the opposing party here is using my client's previous medical issues that she's having. She does need a liver transplant. And he is using that as a reason to deny my client parenting time. Right now, my client has not seen the
I agree. However, and that's, that's called framing an argument here. He's framing her as a victim in this, but your client's medical condition is that she's a flaming alcoholic, apparently. And using that to deny her parenting time is entirely legitimate. So, that's where we are.
minor child or had him overnight since June 28th, Your Honor. And it's become readily apparent that the opposing party will not exchange the minor child for an overnight parenting time unless a temporary order is entered. So we're asking that the court do that. We just rely on what we said in our motion.
And it's my understanding that we had a trial scheduled for next week, correct?
We did, and unfortunately, we have to adjourn that, Your Honor. My client does need to be in Detroit.
I understand that she's going to undergo some medical procedures.
Yes.
So obviously, we're adjourning. I was hoping to deal with this issue next Wednesday, but things have changed. Ms. Van Dyken, input, please.
That's the whole problem here.
We had a status conference on this case a few weeks ago. At that status conference, we came to some agreements about implementing the parenting time. And I asked for an order from Mr. Scozzari. I asked for an order, then he sends me an order that doesn't comport with what we agreed to in the status conference. I simply crossed off what he put in there about makeup time. We didn't agree to that. And I asked him to enter the order. And then after I sent him the order, with that paragraph crossed off, I sent him emails. Have you entered the order? Where's the order? Where's the order? My client wants an order because this has been the problem. Hang on.
She's good. I agree. I've been through this stuff. Okay, so they had a discussion. They didn't have an agreement on makeup time, whatever the hell that is. And then this guy just tries to throw it in the order. Well, hell no. She's actually nice about it, but she's not having it.
We also requested her medical information. We have not gotten that yet. We would like proof of this appointment next week because this case has been adjourned no less than 5 times.
Yes. Let's also not assume she's telling the truth. She probably is. Who knows? But you know that this woman's put this guy through hell, and you know she's an addict. So that's what they do. So let's just not assume everything that comes out of their mouth is true.
This has been going on for over a year. So every time something comes up, she's got a medical appointment, she's got this going on, she's hospitalized, she needs a liver transplant. I need to see proof of this.
And again, we're doing it because we've based everything on the fact that she's got some medical issues that need to be dealt with because of her past background. Mr. Scozzari, is there an order floating around that has parenting time on it?
There is, Your Honor, but the primary issue here is that my client is deserving of make-up parenting time. I mean,
and we can argue that at a later date. Let's get the order in and get some parenting time going for her now.
Certainly.
What I would say is go ahead and reserve an issue of make-up parenting time for the trial, and it may or may not be granted. The idea is let's not glut this up when there's a parenting time agreement that could be put in place, and then she could start seeing this kid.
That's fine. And Your Honor, I just want to add, I did just email Ms. Van Dyken proof of my client's.
Okay, good.
Your Honor, these parties are also supposed to be using a backtrack device because of the history.
Yes.
And I have not seen Miss Evans' backtrack usage.
I haven't seen Mr. Nowicki's either, so I think
I sent him to you.
Exchange that, please.
I haven't seen Mr. Nowicki's. I sent him to you, and I'm not worried about it. We both know that that's not where the problem is here. Oh, I like her. I like this attorney. She is not having this, and she's right. She's just advocating properly in this situation.
What I don't want to have happen is that something unfortunate happens with Miss Evans' medical treatment, and this kid goes without knowing a mother at all. I'm assuming your client still is on the waiting list for the transplant, sir?
Yes, Your Honor.
Okay, and it's got to be a complete transplant, not a partial?
I think Miss Evans can probably speak to that a little better than I can.
Yes, Miss Evans.
As of right now, we had lab work done yesterday, and every single medical blood lab work, they do a complete metabolical panel, including alcohol. They did that when I was hospitalized, right when they got me.
No, we don't know. I mean, does she sound like she's sober to you?
Throughout the entire time. I have another appointment today that has an alcohol panel on it as well. Backtrack does not work for me because I am on multiple prescriptions.
Backtrack does not work for me because I'm backtracking all day long with alcohol. That's the way I read it. I don't know. I'm not there.
That make it go off. And I can show proof of all of my medication as well.
Well, if it goes off, then we need to know what the medications are that are
right. And that's why
interfering
they
with it.
said, and
Because
I
obviously,
agree with that.
obviously,
And-
medications going off is going to be fine.
Right.
Yeah,
And
they're looking
Backtrack
for a
has-
very specific thing that you've been using in the past that will show up as a different part of that.
Right. And Backtrack.
Why won't this judge say alcohol? Like it's taboo, you know? He just tiptoes around her the whole time. I mean, he's doing fine. Like I don't, but just I don't understand this massive sensitivity. She's drunk. She's got an alcohol problem. Let's say it.
Backtrack has asked me to ask my legal representation to find an alternative to Backtrack because of that purpose.
I think what my client is trying to say is that, you know, based on the fact that she needs this liver transplant, you know, she's having, obviously, in order for her to, hang on, Aaron, in order for her to, you know, get that transplant, she has to show that she's alcohol free, right?
Right.
So I think, you know, I'm happy to provide Miss Van Dyken any backtracks that I do have.
Please do. And if those backtracks show that she's using the medications appropriately, that's what it should show. But continue to use backtrack until you can find a differing. Let's see if we can get. Is there something out
It's
there?
gonna go off every time I take it, though.
Yeah. So I think what
I agree with you there. I I agree with you there. There's going to be sirens and bells ringing and all sorts of stuff, but it's not from your prescriptions.
Well, if it goes off, as long as it doesn't show alcohol, you're fine.
It shows it with the prescriptions is what I'm trying to
yeah.
say. That
Yeah.
Backtrack has agreed to that.
Right. Okay. As long as it's not showing alcohol, you're fine.
Okay.
Right.
I think what
But
we can-
if you could find something else that may be agreeable between the attorneys, that would
I
not.
think that would be a blood panel, but
I think we can
Yeah.
show the blood panels and all the other stuff because obviously that's happening regularly now that she's on this transplant
I
plan.
would be
Yes.
happy to have Miss Evans do a hair follicle, but I'm unsure if that would,
I don't think it would show it.
a hair follicle does go back. I just did one this morning with Judge
Right.
Gottlieb,
Or-
goes back 90 days.
But it goes back 90 days. Does it do so on alcohol as well?
It does. It does.
Really? Okay.
Yep. I'm happy to have her do one of those.
Okay.
I
Why
think that
I
would
would
be
be
fine.
happy
Well,
to.
yeah. Go ahead.
Okay.
Go ahead.
And I can send over my panel from today as well if you
Right.
just want those.
Please, more information is better.
Yeah.
All right.
Perfect.
We want to make sure that the child's going to be safe with you. That's all that's been a concern. And we understand your medical issues, but there are some concerns here, and we need to make sure that parenting time can occur, but done safely. That's why all these safeguards have been put in place, ma'am. So follow through with them. Mr. Scozzeri, strike the portion that says make up parenting time.
I can do that.
If you want to enter a separate order that says make up parenting time is allowed to be argued as part of the issue at trial, great. At this point in time, I'm not sure what makeup could be done because of the
Mhm.
issues that are underlying this case.
And we'd probably need testimony on that, so that's
Oh,
fine.
well, you would, and whether it would be granted or not is a whole nother question. Like I said, there are some issues in this case that have been ongoing for months. So since we have to delay the trial again, we'll get with you for a new date, get that order entered and follow it. Since we have one out there,
We can do that.
Okay, so will I be
Yeah.
able to receive my child this weekend?
is that what the order? I don't know what the order says. So that was going to be my when I interrupted Miss Van Dyken before she started to talk. My only question was going to be,
That's
could
my
somebody
thought.
have attached the proposed order? I don't have it. So, but
We can do that. We can just
if
work
you
off of
email it to me, I'll be more than happy to sign it this afternoon.
Okay. Stacy, we
All
can
right.
just work off of the one we had. I'll strike that makeup parenting time provision. And
I'll
then,
send
Yeah.
you the information about a hair follicle, where to take it.
Right.
Oh, Stacy, don't worry about it. I hate this too. Oh, it reminds me of my practice. Oh, Stacy, don't worry. I'll take care of that. I'll strike that provision that I tried to sleaze by when the judge wasn't, in the conversation. But now I'm going to be all magnanimous about it. Oh, okay.
Okay.
Perfect.
All righty. Good luck to everybody. Ma'am, good luck with your medical. And sir, thanks for taking care of the kid.
Thank
Have a
you.
good
God
morning,
bless.
everybody. Take
Thank
care of
you.
yourselves. All righty. Good luck. Stay safe.
Well, there you have it. That's what I have on a Sunday from Africa. That's all I got for you. I thought that was pretty interesting, though. I hate to harp on this, but if the roles were reversed, if you had a guy, dropping dirty left and right with a major history of alcoholism, there'd be no discussion in court as to his parenting time. He's out. Done. We don't trust you. We don't trust you to be around this child. But since the genders are reversed there, let's do backflips and try to figure out how we can do this. And then the judge who doesn't want to say anything about alcohol then goes and says something much more contentious. He doesn't mean it that way. His heart's in the right place. But the judge who's afraid to use the word alcohol is then just drops casually in the conversation. Well, I'm kind of worried about her parenting time because I think it might be the only time that the child gets to see their mother in the event that the surgery doesn't go right, which is a completely rational and reasonable thought to have. And I think that's what's really motivating him here. So yeah, I mean, it's a sad situation, but I think she's drunk there. I don't know, or maybe she just messed up from being drunk so much. I don't know. I'm not there, but if I knew nothing else about it and you just pulled that snippet out of context and played it for me, like, that person is drunk. That's what I would say. That is the way I see it. All right. Thank y'all for coming out. I will see y'all soon.